Hey, welcome everybody. This is Phil Grove with the Canis Major Incubator video blog, our weekly blog talking about commercial multifamily investing in Texas. Each week we cover a different strategy, technique, principle, and this week we have a very, very special guest, Roland Wiederaenders, who's a securities attorney here in Texas, is going to be giving us a special presentation on how to review a commercial multifamily private placement memorandum. So, Roland, are you on the phone?
Yes, sir, I am.
All right. Well, Roland, I'm going to turn it over to you. Take it away.
Okay, thanks, Phil, and thanks everybody for joining us today. Like Phil said, my name is Roland Wiederaenders. I'm an attorney, and I grew up in Austin, Texas, and practiced here for about 20 years. I do need to start out from the outset. You know, Canis Major is created as an organization really designed to educate investors and provide people with the tools that they need to properly evaluate their potential investments in the deals that we're going to be promoting or we're going to be that will be available through the incubator. But I have to emphasize that I represent personally the incubator as its attorney, and also serve on the board of advisors. And so this advice here doesn't constitute legal advice. I need to emphasize or encourage you to hire your own attorney and your own financial and investment advisors. And this is really designed to be an educational tool to provide you with additional information or how to just evaluate these investment opportunities. But please do rely on your own advisors as well. As I noted before, I've been an attorney for about 20 years, practicing in the area of securities laws primarily, and I've represented mostly small to medium-sized companies my entire career, and do represent a lot of real estate developers here in Austin. There's a lot of real estate growth, and so a lot of people are putting together partnerships, large and small, to take advantage of the opportunities that are here. And like what we're talking about here, this is commercial and multifamily investments, and this is exactly the type of work that I do, is help people put together small, medium-sized partnerships that will go out and find investors. Those investors contribute funds that in turn are invested in these projects, and then the managers of the projects go on and provide reports to the investors, define the terms and everything. But that's what we're talking about here, is giving you again the tools that you'll need to evaluate whether this is a good investment or not. And every investment opportunity, an investment in private security, starts out with a PPM. And what this means, that's a defined term. It's a private placement memorandum, or they're called other names as well: confidential private placement memorandum, or offering memorandum, disclosure document. And I'll just refer to them herein or in this talk as a PPM. But this is what this slide sets forth is the standard for when you have an issuer of securities, any company that's seeking to raise money from an investor, they're required to disclose all the material information that you would need, or that a reasonable investor would need to make their investment decision, and also not fail to disclose anything where that failure is material. And I give a couple somewhat silly examples on this page, but I think people understand this generally, that you want to know everything about the investment, and you don't want the person that's sponsoring the investment to stay silent about anything, where you'd really want to know that to make a fully informed decision. And this is a standard in the securities laws, actually. If you've ever heard the term 10b-5 or anti-fraud rules, that's what this is expressing here. Just real quickly, what is a security? I mean, that's a pretty big question, but here, the securities that you'll likely be purchasing will be interest in an LLC, a limited liability company, or partnership interest in a partnership. Securities may be denominated as units, or you may have a percentage interest in the partnership, and either way is okay, just so long as you understand. But the difference, but many times a manager, a sponsor will denominate even a limited liability company interest or partnership interest as a unit to make it more like a corporation which has shares. And it's going to be highly unlikely that any of these investments are going to be an investment in a corporation unless they tell you specifically that it's a REIT. And a real estate investment trust, that's an acronym for real estate investment trust, and it's just a special type of corporation that invests in real estate, and it's taxed more similarly to a partnership than a subchapter C corporation. And really diving into this, how I've broken down this next section of the presentation is the different sections of the PPM. When you open it up, you'll see, different titles of the sections, and these are the ones that you want to pay particular attention to. The first, one of the first pages should be an executive summary, and if you just have maybe a few seconds to evaluate or to look and see whether this is something that you're interested in, turn to the executive summary page towards the front, and ideally it should provide you with a story about what the investment plan is, who's executing it, and also they may start immediately talking about the projected results. And it's good to kind of go through this, and one of my points later on is just reading this document like you would anything else. If there's a bunch of mistakes or inconsistencies, that should be a red flag. This is a document that's produced by an attorney. In my practice, I really focus on the final product being letter perfect and completely internally consistent. And many times in these documents, you'll see descriptions of the same thing repeated, and if they do it different ways, then obviously that's a red flag. There'll be another section generally that discloses any related party transactions, and important to note here is a lot of times a manager or a sponsor of a deal will engage parties that are related to them. There's really nothing wrong with that as long as they're disclosing it. An example may be that a deal sponsor is related to a broker that helps with the acquisition, and they've got to engage some broker, but just may be that the broker's related, or a construction company. You can really think of any type of relationship, any type of service provider to the issuer of securities. It may be related to that person, and like I said, there's nothing wrong with that as long as they disclose it, and they'll probably say specifically in there that they're engaging that person on terms no less favorable that then could be obtained from third parties. You want to make sure that they're not using your investment dollars to give some special brother-in-law deal to a relative. And that's rare, but they should have disclosure regarding that, and they may even name specific parties, and you have every right to ask them, hey, tell me about this deal. Is your brother-in-law really the best person we can get to work on this? The most important part of the PPM is a summary of terms, and this is a summary that will describe in pretty good detail all the specific terms that you'll find in the company agreement or the partnership agreement. And when you make an investment, essentially you're signing a contract, and it's an agreement where you agree to contribute dollars in exchange for, these not shares of stock, but their interests in a limited liability company or interest in a partnership. And that's the contract that you're entering into. The PPM that I'm talking about is just a disclosure document, and it's describing the investment, but it also does describe those definitive terms that are in the company agreement. And as I mentioned later on, or here as well, along with the PPM, along with that disclosure document, the manager should be handing you a copy of the company agreement or the partnership agreement, because that, things go wrong, and unfortunately that's what I'm typically engaged to do is to think about what happens in the worst case scenario. You're going to go and look and see what was said in the PPM, and then what the specific provisions of the company agreement provide. And if you do have a worst case scenario, a lawsuit occurs, you'll be bringing a breach of contract suit, and the contract is that company agreement or the partnership agreement. So that's why it's so important to really understand what that says. But as an aid, the manager should give you a good summary of terms to try to explain it more, and maybe not layman's terms, but a reasonable investor should be able to look at all of these and say, oh, okay, this is reflected in the company agreement, be able to compare and find the specific terms of the company agreement, but they're all summarized here. The first thing that people should really be aware of is the securities that you're purchasing are private securities. That means that you can't go to your broker and say, sell 100 shares of this immediately. You're in this for a term of years, and there's a possibility that you can transfer your ownership interest, but you'd have to find another buyer who's interested in buying into the deal, and also the manager of the deal is going to have to consent to that. So that's something that's really important, and they may impose some additional restrictions. So pay attention to those. And the identity of the managerial authority or the manager, who is it that's sponsoring the deal? And note that for LLCs, the sponsor is going to be defined as a manager or maybe a managing member, but generally it's a manager, and that's the same thing as a director, like on a board of directors for a corporation. And less likely now, if you're investing in a limited partnership, the managerial authority is the general partner. So there'll be a general partner referred to in the PPM, or a manager. And then a lot of times those may be entities, so they're in turn controlled ultimately by individuals. And as I'm refer to later, you want disclosure about the individuals that are controlling the deal, and they'll provide biographies, biographical information. They should provide you with historical work experience, education. Ideally, you're going to read a bio of somebody and you're going to feel good about them sponsoring this investment, that they should reflect that they've got significant experience, at least, in sponsoring commercial multifamily types of investments. And that's one of the things that we really look for at Canis Major, is to make sure that our sponsors, the sponsors of the deals that we present, are good, have good experience. We don't want people that just haven't shown some degree of track record. You should pay attention to how your investment is going to be funded. Will you pay cash up front, or will there be a capital commitment? And with a capital commitment, what that is you contractually agree to fund your investment at some point in the future. And this happens typically where the manager has a deal under contract, but there's a closing date sometime in the future, and they'll say, okay, with your capital commitment, I'm going to notify you that you have to fund that 5 days before closing. And if you don't fund that commitment, there may be penalties associated with your failure to fund, and it's an enforceable obligation for you to fund that. So I would encourage people not to ever, sign up for a capital commitment they're not certain whether they're going to be able to make it. And then an important consideration is who are eligible investors, and almost always you're going to have a deal sponsor that's focusing on taking money solely from accredited investors. That there are some instances, particularly under 506B, where non-accredited investors can participate as well, but that'll be something that the deal sponsor describes specifically. And considering those securities law exemptions is an important thing to think about, and your securities attorney should advise you regarding that. The terms that's going on, there should be a description of how long your investment is going to be at risk. What's the expected term of the fund? The sponsor should tell you what their plan is for buying the asset, whatever capital improvements, if they're going to increase rents, how long is that going to take? When do they expect a future liquidity event, refinancing, sales? They should have a good story about that because you need to know how long your money is going to be tied up. This is super important. How will the managerial authority be compensated? Look for the use of the term fees in the PPM, and they may be described in many different ways, but acquisition fees, I list some here: disposition, refinancing, guarantee, management, carry, performance-based fee. And then one thing really do a deep dive, ask the manager whether they're sharing their fees with anybody whose identity is not disclosed in the PPM. I think it's good to understand how everything is working, and we encourage at Canis Major the managers to be forthcoming and to give people all the information they need to understand how the deals come together and how people are being compensated. I mentioned this earlier, but the managerial authority only acts through individuals, real live human beings, flesh and blood. And I note here that ideally you're not going to be investing in a deal that's sponsored by a single individual. The reason for that, there are a couple, but one is internal controls. We'll talk about this later, but also what happens if the proverbial bus hits the manager, who's going to take the investment and make sure that they can execute the plan for profitability that they described. An important question here is how much do the principals or persons related to the principals, how much have they invested in the deal? That's a really important consideration, because the more money that they've got at risk, I would argue that they're more highly incentivized to make sure that the deal works, because they've got their own skin in the game. Projected returns, they should give you information about that. Too high should make you suspicious, but you should be equally suspicious if they don't include any or targets that are unsupported. Very important. How is cash going to be distributed? If you don't define the different terms, make the manager tell you how that preferred return works, or how the catch-up works, or how the splits shift. A lot of times you'll have 100% of cash going to investors until a return of their investment, and then there'll be an 80-20 split or a 50-50 split. Pay particular attention to those provisions, and one of the important provisions regards tax distributions. And if you invest in an entity that taxes a partnership, it's possible for you to be allocated income without a corresponding distribution of tax. And so that means that you would have to pay for the tax liability associated with that investment out of pocket, without cash that's been derived from that investment. They should tell you, where their financial data projections are included. Maybe not in the summary of terms, but this may be more an exhibit. But this is definitely something that should be disclosed somewhere. They should define leverage limits. Are they going to be using leverage? Leverage creates the possibility for increased returns, but it also increases the risk if we can't pay the debt. So that's a very important consideration. Are the principals of their related parties providing guarantees to the debt? That's, when you go to think about maybe removing a manager for failure to perform, it may be that they have these guarantees in place. And what I've done recently when I represent managers is I'll say, hey, listen, let's include in those removal provisions that your members, if they get mad at you, then they can remove you, but they also have to release you from those guarantees. And just depends on which side of the transaction I'm working for, but that's just a real important consideration, because with debt, it's pretty rare that, you should ask. It's possible that they've been able to obtain debt without the use of guarantees, but it's a consideration. Again, we talked about, I think maybe I went backwards. Expenses, what expenses the issuer bears, their costs associated with organizing the fund, legal fees. But one thing that the fund, your investment shouldn't pay for the cost of the manager's overhead unless that's specifically disclosed. And I would say for Canis Major investments, we really try to focus on managers that don't look to cover their overhead through the expenses that are borne by the fund. Reporting, they should summarize here what types and the frequency of reports that you'll receive. Sometimes if let's say a manager is raising $1 million and you come in and say, I'm gonna invest $500,000 with you, and I understand there'll be other people, but because I've invested such a large percentage of the overall that you're raising, I want you to agree to special terms for me, and that could really be anything. People might agree to reduce a fee for a significant investment amount. Maybe special liquidity terms might be a little rarer here, but this is a possibility. And if you're wanting to maybe have a more active role, know that a manager might accept different terms if he knows that he's getting a significant amount of cash. And I will note that I use the pronoun he here a lot, but just understand this could be he, she, really non-discriminatory here. So just using that loosely. But going on, we talked about related party transactions. They should also disclose who important service providers are. Attorneys and accountants are generally the most important, but sometimes banking relationships will be disclosed as well, because the bank may come to you and require certification in some instances. For instance, like if you've made a capital commitment, the bank needs to know that they're providing this financing, but you're reconfirming, you're acknowledging the capital commitment, because it all has to work together, all the financing sources. It's a little minor point, but the manager might provide disclosure about how they're going to be devoting, they won't be devoting all their professional time to this investment. That's okay, but as long as they're devoting the necessary time that's required to make this investment work. Use of proceeds. So I guess that's really winding up the summary of terms. Another section you'll find is use of proceeds, and here the PPM should provide you disclosure about what managers' intentions are with respect to the money that you've invested, and they should provide you with a good plan, a budget, the acquisition budget. If there are capital improvements, they should be able to describe all of those things to you, and making sure that they have a reserve for working capital if that's necessary. So the use of proceeds is real important, and you can drill down there and really quiz them. Have they really considered all the contingencies? The next section of the PPM is risk factors, and these are generally pretty generic, but what I encourage you to do here is pay particular attention to any risk that appears to be specific to your investment. And it's hard to say what this is specifically, but you can spot it by anything that doesn't just appear general. All these investments, real estate is an illiquid asset. Your investment is illiquid. As a member, you probably won't be participating in management. These are disclosure risks that are applicable to all of these types of investments in private securities. But look for ones, and I give another example here of the manager. You've got a sole manager, has terminal cancer, is going to die in 6 months, and there's no plan for any successor. That's a very specific risk. That if you see that should raise a red flag. I think that goes without saying. Tax consequences. There should be a separate tax consequences section, and in all likelihood for individuals and for-profit investors, there's not going to be much of a surprise here, but you should note that there'll be maybe disclosure provided about how we'll be delayed in delivering your Schedule K-1s to you, so you may need to file an extension for your tax returns. And exhibits, I mentioned this earlier. You should not only get a copy of the PPM, but typically they'll also include a subscription agreement, which is like a purchase agreement that you'll sign, agreeing to purchase the securities. And then they should also have the company agreement or the partnership agreement. Like I said, you're going to be suing under that if you ever have to go and litigate. Those are the definitive deal documents. Whether they're included or not, make sure you review them before funding. Make sure your advisors review them. And if the manager is at all hesitant and says, well, why do you need to see the company agreement? That's a big red flag, because they should be very forthcoming about all these documents. A business plan, financial information, all these things are typically provided as additional disclosure beyond the PPM or as parts of the PPM. And finally, at the end, I'm wanting to just point out a couple hot button issues that you should pay particular attention to. The first one is, can the manager sell and issue additional securities without your consent? What this means is if the manager tells you up front, I need $1 million and we're going to be using 75% leverage, so we've got a $3 million loan, we're going to be going and buying this apartment complex or commercial property for $4 million, and we've already worked out the rehab budget and working capital, all of this. So the maximum amount of money that we're ever going to need is $4 million. Well, what happens if there's something unforeseen or we all know that we can't foresee everything. If the manager needs more money, what are they going to do? And they should maybe even give you disclosure about that in advance. And at the very least, I'd like to say, or I really encourage all my investors, and I tell the companies that I represent that this is really a fair term, that in these circumstances, because you control the deal and because or you should know how much money you're going to need, let's tell people that if you do need additional money, you're going to sell additional interest in the fund, you're going to go out to the investors first and make sure that they're okay with what you're doing. And you're going to give them an opportunity to buy their pro rata share so that they're not diluted. And this just generally brings up a point about looking very carefully at what the manager can do and can't do without your consent. But typically this is, how to raise additional funds if necessary is an important consideration. Internal fraud controls, and I mentioned this before, that, really simply, one way of guarding against this is making sure that there are always at least two people that are really involved in the management of the investment, their internal checks, so that if one person is doing something, then the other person, there's at least a possibility that another set of eyes is looking at them. I guess they could both be in on it, but I think the possibility is reduced the more people you have involved. And then also think about how financial results are verified, or if they are at all. How are they preparing these results? Is there underlying data that you can maybe request to verify it? And are they having their books audited or examined by an accountant or bookkeeper? Succession planning, if there's only one manager, does he have a plan in place for how he's going to turn it over if he can't fulfill his obligations? Does he have an assistant or another partner? Or, I've worked this out with a client one time that they were going to turn it over to me. I had instructions for how to liquidate the investment. And then this is important too, the power to remove. Think about if the manager isn't fulfilling their duties, how can investors remove him and replace him with somebody else? And finally, I mentioned it, clerical accuracy and internal consistency. If you've got a messy document or a document there's a lot of typos, that should be a red flag that the manager is not paying attention to something that's really an important aspect of their business. The PPM, in the end, is going to prevent people from coming back around later on and saying, hey, I didn't know you were going to be taking my money and investing in that. I thought you were going to be investing in this other investment. And the manager is going to come back and say, no, here on page 12, I told you specifically that I'm going to be taking your money and investing it in what you said that I didn't tell you about. But I can't emphasize enough the importance of having your professional advisors and the attorney looking at this and advise you before making your investment decision. What we try to do at Canis Major is provide you with education, additional information that you can use to evaluate these investments yourself. But as you know, there's a lot of complexity in these, and you wind up reading, at least 100 pages of legalese, and for people that aren't trained in that area or haven't spent a lot of time with it, it's good to have an attorney, another set of eyes, making sure that everything that the manager says is what they're actually doing. And that's really the end. Phil, I guess I'd turn it back over to you.
Well, thank you so much, Roland. That was a very great presentation on basically evaluating a PPM. And I will say the Canis Major Incubator, it's a platform where we basically connect people with deals with people with money. Although we don't sponsor deals ourselves, we do try to put things in place to create a better environment for the investors. We have a board of directors that evaluate and look at the deals to see if best practices are being followed, that help vet the sponsors. We only invest in Texas real estate, and we allow the investors to actually see the investments and actually meet the sponsors and actually be part of a community of investors. So when you're evaluating a deal, honestly, I want to see the property. A picture is worth 1,000 words. Well, an experience is worth 1,000 pictures. And there's nothing that just beats the experience of actually walking around the property, the neighborhood, seeing what this thing really looks like. You could write a 1,000-page document that wouldn't replace that experience. But when you're investing in commercial multifamily investments, you're not just buying a property, you're also buying a business. So I want to meet the guy, the sponsor who's actually put this plan together. I want to shake his hand, get to know him, be able to ask questions, have some kind of a relationship with him, because I'm investing not, again, just with the property, but with the person who's putting this whole thing together. Having some other experts that can help to vet and oversee some of these things, and also having a community of people that I can also share tribal knowledge with. You know, I'm going to look at each deal I would potentially invest in, and I'm also going to ask other people in the community what their thoughts are on the investment. By combining my thoughts with theirs, you know, I get a little bit higher level of comfort in understanding these types of investment opportunities. Canis Major tries to put these types of resources in place for the community, as well as some other safeguards to try to get the very best investors and the very best investment opportunities. So, Roland, anything else to add to all of that?
Well, no, and I think that emphasizing the importance of what you just said, Phil, is this community, and you know, we have great resources here, and really trying to create an environment where the more you know, the more choices and options you have, and it's exciting for me, because I think the more informed investors we have, the better the experience is going to be for everybody.
Sure. And also, Canis Major, of course, provides a tremendous amount of education for real estate investors that want to invest in commercial multifamily properties. So thank you so much, Roland, and thank you all. We'll see you next week on the next commercial multifamily Canis Major Video Incubator blog. Thank you, everybody.